Hi, everybody. Good morning or good afternoon, depending on where you are. I hope everybody is doing well. We're just going to take a minute for people to filter in. I'm not sure that's the right word. So we have put up here a list of the co-organizers of this event. And if we just wait a minute, we'll get started. So let's just give 30 seconds. In other words, not a minute, but bear with us. It's been an incredible news day regarding data. I don't know if you have heard about the World Development Report, but it was released today and I look forward to reading it. A lot of it is about where our trade governs data. And so it's a good time to have this discussion. So welcome, everybody. I'd like to introduce our three speakers. I was surprised that I didn't get the usual comments on Twitter about a manel, but nonetheless, we are really privileged to have three senior digital trade experts. So our speakers today are Nick Russell, who is the Deputy Director of the Digital Trade Team for the UK, Nicholas Schubert, who is the head of the Department of Digital Economy for the government of Chile, and Darren Smith, who is the Director of Services, including digital trade at Global Affairs Canada. So what we're going to do is I've got some questions for them. And then at around 11:30, we'll open the floor up, maybe a little earlier, to your questions. So let me begin, guys, by asking, does your nation have a definition of digital protectionism? Let's go in alphabetical order. Nick, do you want to go first?
Yeah, happy to, and thanks, Susan, as well, for the opportunity to have this chat this afternoon or this morning, depending on where you are. So I'm not sure we have the definition of digital protectionism. I'm not sure anyone has ever asked us either. And I was trying to read this definition over and trying to kind of think whether I agreed with it. And for me, the question is, like, what's the point of trying to define it and what we're trying to do here? There was maybe a more well-known US definition of something, which was the definition in the Supreme Court of obscenity, which is you don't know what it is, but you know when you see it. And I wonder if that's maybe a more appropriate definition of digital protectionism. I might come on to this when I come on some of my other answers later, but I think looking at stuff purely through a lens of protectionism is maybe looking a bit too narrow at the issue. And there are other questions and other reasons why when we look at it. So we don't have a definition. I think there's some interest in the one you put up from the US, but for me, it's probably more complicated than actually what this definition sets out.
Thank you. Nicholas Schubert?
Yeah, thank you, Susan. Thank you for organizing this, and thanks for the invite. Good morning, good afternoon, and good evening to everybody that is joining this meeting. I'd like to provide a developing economies perspective on this, which is very much linked to the need to maintain, I would say, a particular technical design of the internet as the infrastructure where digital trade is happening. We are confident that the internet's values come from providing a global, open, and competitive platform for everybody to innovate on. And in this regard, this definition matches our concerns with specific measures that have been adopted and that tend to disrupt a particular architecture of the internet that has consequences on the overlying economic ecosystem that works on top of it, of this infrastructure, of this global infrastructure. And these measures include localization requirements, not allowing data to flow across borders, and measures that grant a different treatment to digital products than to traditional services or goods. And if I may, I'd like to expand a bit on why we think these measures are problematic The reasons are very much linked to the idea of having this global market, which is particularly important for a country like Chile that relies heavily on international trade and has a population of only 80 million people. And in this regard, impeding data flows creates a problem, since the internet is fundamentally a packet switching network that moves data, ones and zeros, bits and bytes, whatever you name it, from one end of the network to the other end. And if data flows are restricted, you automatically end up with a segmented market that that doesn't allow trade to go to its full potential. And the same is true in the case of data localization, but I'd like to add another perspective to this particular piece of the debate. The general justification of localization measures is to protect sensitive information, or at least that's the justification that we've been hearing lately. But it also serves the purpose of forcing providers of services or digital products to locate their infrastructure in a particular territory. The approach that we have to this issue also includes another consideration, because being a small market, as I mentioned, only 80 million people, we can't afford to force anyone to locate their data centers here to provide products or services. And instead, we rely on providing a good environment for investing here. And finally, there is an ongoing debate if digital products should be treated as services or as goods. Many WTO members think that they should follow the rules of the GATS of services. But to my mind, there is a certain protectionist approach to it, because the GATS system allows for a broader for broad exceptions to be implemented regarding digital products. So those are my introductory remarks to this question.
Thank you so much, Darren.
Okay, thanks, Susan, and thanks for inviting me to be part of this discussion this morning. Apologies for my name not being Nick, so that you could have three of a kind for this meeting, but maybe next time. You can try to find two other Darrens, I guess, for another meeting.
We're lucky to have you.
Thanks. I think I'll just pick up a lot of what Nicholas just mentioned. You know, we share a lot of the same views with respect to some of the elements or building blocks that went into this definition. So I won't repeat those. Clearly, our practice domestically and how we forge our international commitments is based on very similar thinking. I guess what I would say, though, is that in terms of your your question itself, though, do we have an official definition? And the answer is no, we don't. I think in part because, you know, while we certainly, you know, note that these are elements that could be viewed as part of a protectionist measure, I think we do have to take a little bit more of a nuanced approach in terms of before we declare something or categorize something as protectionist, just on face value. You know, we don't look at these kinds of things necessarily as, you know, a very binary kind of situation. There has to be, I think, a little bit more examination into the measure itself to understand, you know, why it exists, its purpose, even if it's a permanent or temporary duration, especially in the context of this pandemic period. There's a lot of temporary measures that are have been put in place by various governments. And so there's certainly need to validate that as well. And even to label something as protectionist, you know, we've encountered situations with some of our trading partners where one of their regulatory authorities have put in place something that actually would breach this definition, but that was never its intent. And so there's always an opportunity to perhaps see if there's a remedy around that, and to avoid any kind of, you know, more deepened conflict, I guess, on that issue. Nonetheless, I certainly recognize that there are some governments around here that do have a much more concerted philosophy or, you know, approach to digital trade. You know, in some respects, trying to replicate, you know, import subsidization, industrialization for a digital age. You know, there are various countries that are experimenting with those kinds of ideas. And that is, of course, a broader concern for us, and why we want to tackle some of these issues in the WTO context. And of course, we continue to do so in a regional and bilateral context as well. So, you know, I think that there's, you know, also some utility having these types of definitions when you have those kinds of, you know, naming and shaming lists that get published, sometimes by governments, sometimes by think tanks or other kinds of industry associations. And they're informative, but at the same time, we also can't read too much into this as well. as I said, there's sometimes a little more nuance to some of these issues, and it's best not to necessarily, judge a book by its cover, so to speak. And that's why, these definitions, while helpful to help guide the discussion, they're not, as I said, definitive and require a little bit more work to make sure that it does indeed fit, or can be viewed with multiple criteria, indeed a protectionist measure.
Thank you for those comments. If it's okay, can we skip to just what's in trade agreements already? Like if we were to summarize that, how do trade agreements address digital protectionism? Maybe they address some of the barriers, but not all of them. What are your thoughts on that? Let's start with you, Darren, if you don't mind.
Sure. And I think these are clearly some key provisions in which we have in our FTAs and are also being addressed currently in the JSI e-com context. So I think it's a very important point, that was the first bullet, that we're not starting from scratch. We do have a very strong foundation within the GATT and GATS that are being now enhanced through our FTAs and our WTO work. And I think, one of the other things that's really important too, in terms of how we address these issues, is just more broadly speaking, provisions that address transparency or provide transparency. That's the first thing you have to take care of. Understanding, how to first find these laws and regulations and see how these laws and regulations are also developed, and opportunities for, stakeholders to comment and to provide views on the development of these types of laws and regulations is key. So without transparency, that's the first step in the process, I think, that has to be addressed within the context of a trade agreement. And so there's those kinds of horizontal elements, I think, are the foundational building block. And then some of the other the two other bullets that are here in terms of dealing with PRs, or you're talking about data localization or source code protection, things like that. These kinds of enhanced rules, I think, are key. But I like the fact that you also added the third bullet here as well, is that we're not only addressing so-called barriers to trade, but we're also dealing with issues or impediments that might degrade consumer trust and confidence in online space. And that is definitely, I think, part of the balance that has to be achieved here. The way we look at it in Canada is kind of like as I think I've talked to you before, is kind of like a triangle. You have on one corner our work that we're doing in terms of facilitating trade in the digitally enabled areas. Then you have, of course, the impediments, including things like data localization. And then you have the third corner, which is key, is consumer trust and confidence. And without all those three working in continuity, you don't have, I think, the kinds of constructive outcomes that we need from a trade policy perspective.
Thank you so much. Nicholas Schubert, would you like to comment on that?
Sure. No, thanks. And I tend to agree a lot with what Darren mentioned. I think to us, the key provisions that we have included in our latest FTAs are data flows, non-localization, non-discrimination of digital products. I think those are the core provisions that we include, always thinking on having a certain respect or a certain recognition of the benefits of the technical architecture of the internet. And I'm sorry that I'm so obsessed with the technical side of things, but so be it. And I think, as Darren mentioned, there are other things that to us are very important. Consumer protection, of course, cooperation. I think we can learn a lot of each other. This is, to a certain degree, the stance that we have taken in our latest FTA with Singapore and New Zealand. It's more than an FTA, perhaps. It's a digital economy partnership agreement, and we really feel this is a partnership because it's founded on intensive cooperation and also transparency. And perhaps I'm answering another question that might come, but I think that in the trade context we should also be including other things that we haven't discussed as of yet as thoroughly as perhaps is needed, and that includes competition, digital payments perhaps, and IP. On competition, I think it might have been easier in 1947 when the GATT was drafted to have a distinct line that everything that has to be dealt with domestically is dealt by competition laws and antitrust and so on, and everything that is cross-border is governed by trade agreements. I think that that border is now blurred, in particular in the context of digital goods, digital products that are born borderless. So I think the WTO and in general the trade community should include more a more competition-based logic in these kinds of agreements that we have. Digital payments is something that is generally not included in trade agreements when dealing with digital issues, but it's certainly a very important part if you want to buy something or sell something. Digital payments is part of the equation. And my remark on IP is that perhaps, and this comes perhaps more from an academic point of view, rather than an official position of Chile, is that we should perhaps think again what the role of IP is, of intellectual property, in particular copyright. In this new world of dematerialized products, I think we should at least have a discussion on that in the context of trade agreements.
Thank you so much for those comments. Everybody, put your questions into the Q&A. Nick Russell of the UK, love to hear your thoughts.
Thanks, Susan. And I'm not going to disagree with anything that either Darren or Nicholas said on this one as well. I think their additions to the list were helpful. So I think transparency is important. I think dialogue and cooperation is important. What I think is important, though, for us as policymakers is to actually think about the real life use cases that our digital trade agreements are seeking to solve. So, you know, what are the cases that, you know, the UK business owner who's trying to do business in Canada or Chile, like what are the steps that they go through and where do they encounter the barriers? More often than not, we often find as well, it actually comes down to the fact that there are no it's not necessarily there is a barrier there, but it's complicated, or there's stuff they don't quite understand. And so this kind of point that I think Nicholas was making about the more that we speak to each other, and the more we use these agreements as a platform for dialogue and understanding, the better that we can improve that understanding within and offer that kind of roadmap to businesses who are trying to work between countries. The only thing that I would maybe add to this list as well is, and we don't do it much in the digital parts of FTAs, but it is more common elsewhere, is interoperability and mutual recognition of systems and how much that needs to happen. So the one that I would really like to see work better and more is on things like digital identity, which I think has a real potential to be a big source of easement of regulatory barriers. If you can prove your identity in another country with using your own systems and not having to use that other country's systems, the amount of work that takes away from it is huge. Now there are quite a lot of different steps that, you know, countries have to go through, the UK included, domestically here to get to this point. But I think there are real opportunities when we think actually not just how can your system look more like my system, but how can your system talk to my system, and how can they discuss things with each other? And I think that might be the real kind of golden goose that we can look for in terms of being able to do this through trade agreements.
Fabulous. So in a sense, if I'm hearing you correctly, you're talking in many ways about how more people can benefit from these technologies through regulatory coherence. And so regulatory incoherence could be a barrier, right? Is that what everybody's saying? How do you get to that negotiations, which, you know, only some FTAs have language on regulatory coherence? I'll start with you, Nick Russell. Like using digital ID as an example, how do you get to that in a trade agreement then, so that it doesn't become a barrier? What kind of language?
I think part of the important thing here is the process, and what you see at the end of the day is the trade agreement itself. What we don't publish are the many hours of discussions that we spend together discussing how we get to that point and how we get to writing those rules. And for me, there is a huge amount of regulatory coherence that comes as part of those negotiations. I mean, you know, you don't FTAs, they have a competitive side, but they're also inherently friendly. They're inherently two countries who want to do a trade deal with each other, trying to come to an understanding of each other's systems. And one of the things that, and maybe it's a comment on something we should be thinking about how we do better, but it is the fact that as well as a final outcome of legal text, before that, there are all sorts of rich conversations which actually do improve, I think, our understanding of each other's regulatory systems, why we do stuff, either because we challenge each other pretty strongly on it. Why do you have this law? Why do you need this exception? Why won't you do this? And the other country will often explain, you know, on if we take digital identity because they haven't got a system in place yet, because they have data protection concerns, or so on and so forth. And then you understand that kind of richer tapestry of things. And I think there are options of doing this, of then helping to resolve this in an FTA. I mean, Nicholas mentioned the deeper deal that Chile did alongside Singapore and New Zealand, which you can see has kind of elements, I think, which are more maybe, I don't know if the right term is discursive in this, Nicholas, but they offer a wider sense of actually, rather than kind of the pure thou shalt not type of law, they offer that kind of wider agreement type of thing. You can do that there. You can do that outside in separate bilateral kind of pieces of paper or agreement with the countries, or you can do it then in how you go back and design your own system and the international interoperability within it. So I think a lot of it does happen. A lot of it happens below the surface that isn't necessarily seen, but hopefully is also still acted upon.
Thank you. Nicholas Schubert?
No, absolutely. I agree with my colleague Nick and what he said. What we tried to do in DEPA was include things that were not included in other trade agreements as of yet, and we did this with a cooperative approach in trying to understand where we're at and where we're going. And some of those things we can't foresee, but we should be open to discuss them as they are developing. And I think this is really key. As Nick mentioned, the process is really key in order to ensure that we have interoperable systems, all of the benefit of having a global open platform where everybody can participate and innovate on. I think the worst is having a patchwork of different regulations. From our perspective, this would injure small enterprises and smaller economies because it raises the cost to comply with different regulations, and this is really problematic, as I mentioned, for all those people that now have the opportunity to be part of the global economy and that they couldn't do that before. So to my mind, we should be able at a certain point in time to have rules that can be applicable to everyone everywhere, but this requires obviously a process, a multi-stakeholder process, even where everybody can participate and everybody's opinions and realities are taken into account.
Thank you so much, Darren.
Thanks, Susan. Yeah, this is one of the reasons why I believe I have lifetime employment is issues like this. It's the crux of the heart of the matter here that we're dealing with, and it's hard because you're obviously trying to achieve a balance between different competing interests here. The right to regulate in the public interest, as we see fit in, say, in our country in Canada, versus, of course, what we hear from business, from both domestic and foreign, that need to kind of help smooth things out. It's hard, especially for SMEs to kind of navigate the myriad of laws and regulations that they have to know about when operating in multiple jurisdictions. So, as trade negotiators, I think Nick and Nicholas, point out some very key aspects: the ability to have open dialogue and to share best practices, and to ensure that our regulatory authorities are connected to the work that we're doing, which can be hard to do, especially when you're looking at something as pervasive as digital trade. There isn't a corner of our economy that isn't touched by this. And so, just trying to ensure that our regulatory authorities are aware of the types of principles that we have embedded in our trade agreement work that's the first thing that has to be ensured is taking place. And to have exchange of ideas and have again information, using our FTAs to, especially in areas that are in more emerging kind of technology areas, to understand how other jurisdictions are looking at dealing with this, giving opportunities to comment. You see the public release of ideas or concept papers or that are feed into the regulatory construction process, and giving other jurisdictions an opportunity to comment on that and identify how that could impact trade flows, things to that effect. Of course, trade agreements can also help provide sort of minimal standards that can be used to work off of, especially in areas like that have a licensing or certification component. And again, a lot of this does come down to transparency as well. Just to know what those rules are, it makes a huge difference. It can help with dealing with compliance complexities that might be in place. So we're never going to get to a point in time where I think you're not going to have what looks like a jumbled group of wires or Christmas lights, for both government and industry officials to kind of look at. But can we smooth things out in certain areas? Yeah, we can, but it takes a lot of effort, and takes a lot of dialogue, and there are limits to what an FTA can do in that regard. Again, it's achieving, I think, a balance, the ability to regulate as we see fit, but at the same time trying to create certainty and predictability in the system. And that sweet spot sometimes is why it takes years to negotiate these agreements.
Absolutely. And yet Nicholas Schubert's DEPA seemed to have moved along pretty quickly. Canada wants to join it. I've heard rumors the UK may want to join it, although I guess CPTPP comes first. We have 8 questions. So let me just briefly ask you guys this last question, if I might. And that is, this is a listing of possible future barriers. I was wondering, starting with Nicholas Schubert, if any of these barriers you think will be addressed in any trade agreement. So we've got here data sharing rules. So that would be like the EU digital policy platform. Algorithmic regulation, such as that in the UK, to try to ban to try to ban discriminatory algorithms. Competition policies that may be seen as going after the US or the UK's large data behemoths. Policies to limit disinformation, etc. I'll stop now. Does anyone want to comment on any of these, starting with you, Nicholas Schubert?
Sure, thanks. And your original question is if any of these issues will be included in FTAs, and okay. Yes, I think some of these issues are already included. For instance, in DEPA, we have some sort of data sharing rules, or at least we created, how do you call it in English? a federated data pool where someone can get data sets that are of economic value. For instance, we had the idea to share with our friends in DEPA the data set that we have on astronomy. Chile is a really big place where you can get astronomic data, and that's a very useful data set for training artificial intelligence and those kinds of things. So I think we should be doing more of that on opening data sets for everybody to use. Algorithmic regulation, yes, this is obviously something that will be included in FTAs. I haven't had the experience so far of seeing a provision dealing with this directly. We included certain issues of a more general nature, making reference to the OECD's work on this ethical framework that we have, but at least to my mind, this isn't sufficient. We should go a little bit further. Competition policies, this is one of my favorite issues. I think this should be included. As I mentioned, there is a disconnection between, I think, the underlying trade rules and the competition logic that should be somehow blended together. We included certain provisions on competition in the DEPA, but more of a cooperative nature, that competition agencies should work together in order to address the challenges that arise from this new economy that we're having. Policies to limit disinformation. Yeah, this might be a little bit out of the scope of a trade agreement, but to a certain degree, we do have certain things, or at least a concern on how to deal with these things. But as I mentioned, this might be a little bit broader than just trade. Privacy label for apps. This is something that we've been working on. We think that also cooperation between consumer protection agencies is key, and providing information to consumers on the compliance of certain products or services is something that might be good. Censorship, it's also a little bit broader to my mind. And cybersecurity rules is something that we included also in a cooperative approach, in the sense that the CSIRTs and agencies should cooperate in order to be aware of the risks or of good practices that have been happening elsewhere. Yeah, I think that's it from my side.
Okay, you don't need to go through all of them, but just however many you want to say. Darren, do you want to go next?
Yeah, I think just at a high level, like, all these issues that are in the left-hand column, have the potential to become a barrier. They also have an opportunity not to be a barrier as well. It depends on how they're actually operationalized. So, but I think it does speak to the fact that the scope and the universe of our issues that we have to consider continues to expand, putting us as trade negotiators in a position whereby we have to continually reach out to a wider array of experts, both within our government structures and outside, to better understand the impacts that these types of issues may have. And then at the same time, we have to obviously make a determination whether we can actually adequately tackle these issues within the FTA. At the end of the day, we're creating a legally binding agreement. Sometimes you can also take advantage of various soft law provisions, best endeavor type language, collaboration type of work to help still tackle these matters. But at the end of the day, we're creating, an international agreement. And it has to make sense. There has to be, we actually have to be tackling, it's a solution. It can't be a solution in search of a problem. We actually have to be addressing a particular problem. And then at the same time, building enough flexibility that we can still address the need to deal with certain domestic policy imperatives, at the same time providing certain predictability in what is clearly an ever evolving and uncertain, environment to work in. So yeah, a lot of different considerations. And I just want to underscore the complexities that we're dealing with. And trade negotiators aren't the only ones to actually tackle this as well. There are other, I think, instruments and other tools that governments can use to also address these types of issues, including in some respects, what we're doing from official development assistance perspective as we work with other countries and provide technical assistance and capacity building so that more countries can fully participate in the international trade components of digitally enabled trade. We have a responsibility as well to find ways where we can harvest our expertise and work with other countries who are still in the more development mode of these kinds of issues to provide our experience, not to dictate what they should do, but of course to provide our experience, our lessons learned, and ways in which we can try to avoid these types of barriers that might actually end up impeding our trade and creating unintended and negative consequences.
Nick, Russell.
So I think my response to this list is kind of which way round are we looking at these things? They're listed under a heading of future barriers, which is maybe it's one side of the coin. They're also, I think some of the biggest regulatory questions that every country is facing domestically, or at least some of them are. I wouldn't necessarily say that we're all facing the question of censorship in quite the same way, but things like competition policies, disinformation, algorithmic regulation, data sharing rules. These are really complicated policy questions that I think we're all looking at in one way or another, internally and domestically. And I think it's part of so the question is, are they covered in trade agreements? And then it's from which angle almost, because trade agreements do as well give space for us to consider these policies domestically and such like. Our recent, for example, our recent free trade agreement with the EU, we gave specific space on in the source code language there. We deliberately thought about the digital competition and algorithmic regulation and disinformation aspects of how that works, and have designed some fairly specific language to help carve that out of those particular provisions. So it's in a trade agreement in some ways, in that it is expressly not in a trade agreement. And but I come back as well to the conversation that got us there, and because in order to get it explicitly not in those trade agreements, we had to have some pretty in-depth conversations about actually this is what we're trying to do domestically, and this is why what we're not trying to do is a disguised restriction on trade. What we're trying to do is solve some of the same problems that you're trying to solve. And I think, as Darren was saying, there are probably other places, frankly, where a lot of those conversations could be had. Is a trade agreement always the best place for doing them? Sometimes yes, but quite often no. And but sometimes the conversations that are had in forming a trade agreement can help lead to a place where you're cooperating more broadly on these digital economy issues. You're having that kind of dialogue, and you're mutually considering as part of it, actually, where do we go to next? How do we take some of these more intangible, slightly larger questions maybe offline and into a different forum to be able to help us sort out?
Thank you so much. Thank you so much for those. Nick, are you going?
Yeah, if I may, I just wanted to highlight one issue that has been nagging our minds lately, and that very much relates to this the question that you posed on future trade barriers. And this is perhaps not a natural trade barrier, but it has to do with how we're governing the internet in general, and how we can make this a participatory and multi-stakeholder process. There are decisions being made at certain venues that affect all of us, but not everybody is involved in those conversations. And then we get, to a certain degree, de facto standards that everybody has to comply with, and not everybody has been part of that. So and this goes back to the idea that both Darren and Nick touched upon. These are things that are not only happening in trade conversations. There are things happening at the International Telecommunications Union, UNESCO, and so on. And I think we need a bigger or a broader approach to these kinds of things, and be willing to include everybody in the conversation.
Okay, thank you so much for those thoughtful comments. I hope everybody could stay a few more minutes to answer these questions. So the first question, I'm not sure I get it, so I'm actually going to skip it and ask Jonathan Brown to rephrase this. And related to data and digital trade. So I'm going to go to the next question, which is directed at Nicholas Schubert, but everybody can answer. Could you elaborate a bit more about what you think are the main questions regarding IP in the digital world?
Sure, happy to. And as I mentioned, please take this from a more academic position, not an official negotiating position. But to me, intellectual property and copyright in particular have become an ends on itself and not a medium or a way of increasing innovation and creativity. So I think we should be rethinking on or thinking about what's the role of IP. Is this the best tool in order to foster innovation and creativity in this digital world, or are there other incentives or tools in order to reach those goals that we want, and for the benefit of everybody, of the whole society, in order to have more innovation and more creativity? Perhaps the traditional IP system was designed and devised in another context that is not perhaps suitable to this new immaterial world that we're living in. So I think that's what I'm talking about when I mentioned IP.
Darren, you want to add anything?
Just to say, I think, I'll echo Nicholas's point too. It's, the focus on these questions can't be strictly from one particular variable context only. IP certainly important, and it's key for us as government officials to ensure that we create an environment that provides for, I think, balanced outcomes in this regard, and for us as well to ensure that our companies that are operating in this domain are understanding of their how IP regimes work and how they can protect their IP assets. I think that's obviously key. So it's one of those things too where there's a lot of very important discussions taking place at international levels, not only WTO but of course at WIPO. And there needs to be, I think, continued continuity between what's happening in some of the developments in the IP sphere, and then of course what's happening more in terms of some of the broader digital trade negotiations. So another, again, point where we have to find ways to ensure that we're not working across purposes, but rowing in the same direction.
Excellent. Nicholas Russell?
Yeah, all I would say on this one is just that markets where IP is not well protected are markets where there are barriers to trade, because there are barriers to investment and there are barriers to kind of IP-rich industries, which many of them fall in the digital space wanting to move into. So, as Darren was saying, it's a core part not just of what we do in trade agreement, but wider at WIPO and through the TRIPS agreement. And I think central to digital, but I would see central in terms of making sure that we really have a kind of a system that supports innovation and supports the kind of the rights of the creators too.
Okay. Let me read another question. What is the best forum to address digital protectionism issues? At the Plural level, through a separate sort of data governance organization? Where? Nick Russell, why don't you start?
So, I mean, I think there's a really excellent initiative here at the WTO and the Joint Statement Initiative on e-commerce. And you know, the idealist in me would say that, you know, that would end up with exactly the rules that the UK, the best in class rules and everything that the UK thought that we should have, and all 80 plus countries would agree on it. Now, there is a reason why those negotiations have been happening for 2 years, and I don't expect to be ending in the next week or two. And it's because it's very difficult to get agreement between that many countries. But I really think there is a lot of value in what's happening at the JSI, and kind of good things take time type of thing. So I would say that countries put a lot of effort and putting a lot of emphasis into trying to get as kind of high ambition and outcome as we possibly can across as many countries as we can at the JSI is a really big part of this. And then on top of that, that's where the kind of bilateral and other deals come in. They're the kind of, I would hope to see them as the kind of icing on the cake element of this. But I think it's right in the question to really emphasize the good work that's happening and the potential that we have got in the WTO, because I feel that's an ongoing effort. And rather than necessarily thinking about other things that we could do, it's really important to focus on getting a good outcome from that.
Darren?
Okay, I think I'm okay now. I certainly agree with Nick. We need to have a strong multilateral outcome to build on our GATT and GATS foundations to have, you know, enhanced rules in the area of digital trade. And I also agree that we're not going to finish this off in the next week, but it's important to keep moving forward in the WTO context. Obviously, there's no other forum that can give us the kind of bang for our buck in terms of both participation and hopefully also on we'll see a high quality outcome coming from this as well. That said, you know, I don't think we're ever going to have like a one-stop shop in terms of this work. You know, I think countries such as ours will continue looking at other available instruments, whether it be our digital trade chapters and our FTAs. And as you know, we're also exploring the possibility of joining the DEPA with Nicholas, because it gives us another alternative pathway. And in some ways, it may be more effective and efficient in addressing some of the issues that we've been discussing this morning. So we keep our options on the table, or available, sorry, and we deploy them, you know, depending on who our trading partner is and what some of the issues are at play, so that we have, you know, maximum flexibility in terms of addressing the interests that we have in the sphere. So I see that, you know, going forward, at least in our case, we can continue to walk and chew gum at the same time, and be engaged in multiple levels of activity in this area. And I think it's not so much, you know, there's obviously there's only so much, there's finite resources and time in which and how many forms you can work in on this issue. We do have to prioritize and ensure that there is not duplication in our efforts, for instance. That's definitely a concern I have with respect to some of the forums that want to get more involved in this area. So for instance, we only view us having one key multilateral forum for dealing with these issues, not 2 or 3 others. We obviously are concentrating on the WTO, but you know, there's others that obviously want to play more in this sandbox as well, and we have to be careful that we don't duplicate our efforts. You know, a good example, I think in our case, you know, it's was just some of the work that was being thought about in other forums on that would kind of duplicate the work of the OECD Services Trade Restrictiveness Index. You know, we have a good tool there. We didn't necessarily want to see the development of other types of similar tools in other forums. You know, concentrate on, I think, on what's coming out of there. So I think that's going to be my one caveat, is that, you know, while we see work taking place on multiple forums, we do have to be careful about duplication and not and making creating inefficiencies that take us away from achieving tangible results where there is more prospect for doing so.
Okay, thank you so much. One of our participants wants to know more about digital identity and the role of China, how that could be negotiated. Does anyone have any thoughts on that? It's a toughie.
I raised digital identity, so I'm happy to mention it. One thing I would say is that I'm reluctant in these things as well to talk about specific countries and specific markets that aren't here as well to kind of have a right of reply. So I won't talk specifically about any other country, but I will talk generally. And I use this as an example of a policy area that I think is at least for us domestically, one that is kind of developing, and one that we are in the UK building our own system and thinking about how our own system works. And as part of that, I think it's really important that when we're doing these things, we internationalize them from the start. So we think about actually what's the kind of cross-border impacts and how do we make these cross-border impacts work. And then when you're doing that, you sort of play out the same questions you're having domestically on an international landscape. So, some of the challenges domestically with such a system are how you get the data protection elements right, how you have a system that is easy to use for users, and how you have a system that is trusted. And so the kind of, once you've made that first step domestically of a system that you want to build, the next step comes in talking internationally and saying, do those questions work for this partner or that partner, kind of thing. So, I don't think there's going to be a moment where all of a sudden we have every country in the world signed up to a similar system and they all work interoperably perfectly. But I think there is legitimate things to think about in terms of how, when you are thinking internationally, how do you think about those kind of core transferable elements that you develop domestically, and then think about how they work in your partners as well.
Any other comments?
From my side, well, I agree with Nick, but I just wanted to mention that I think having a better understanding on the technical tools that are available in order to tackle these kinds of concerns is also important. And in that regard, I think encryption is a tool that is really important in the context of, well, digital identities and data protection. To my mind, if we could devise ways in order to protect data as best as possible and complying with digital identity regulation or data protection regulations in the places where data comes in and then goes out, but in between it's all encrypted. I think this would also solve a lot of the concerns that that we have around. I also agree with Nick that we're probably not going to have a global system that everybody can participate on, but we should strive for that at least. And in doing so, we should also have a look at certain technological advancements and tools that we can use in order to protect things that we want to protect.
Okay. We have a question about the Digital Markets Act, which is proposed, but is it already influencing trade policy discussions around digital trade? Can anyone comment on that, or?
I can. It's not influencing our policies right now, but we are very concerned about the process again. We feel the EU is creating a lot of standards that are to a certain degree worrisome in the way they are crafted, because those policies and those strategies don't always have in mind how this global platform that we were talking about works, and the unintended consequences that might have are not taken into account. So we're a little bit worried about how things are being developed, more on the substance. We can understand why the EU is doing this, but we're worried about not being included in these kinds of decisions. We think these are things that should be developed or at least discussed more in a more inclusive manner, and not just coming up with something that is later imposed to everybody else, as we saw with perhaps the GDPR.
Does anyone else want to comment?
I'll just echo Nicholas's points. I'll give the EU some credit for the fact that they've been putting these ideas out there for comment, and that's good. But there is, I think, and that's not just, there's a number of different aspects. The EU approach here is not somewhat, is I would I'd say altogether different from how they've tackled other areas of commerce. So they're also consistent in that regard. I can point to a number of other initiatives where, the possibility of extraterritorial effect is, in play. So like Nicholas, I think I would, encourage the EU to take into account what some of the comments are getting from their trading partners in this context, and obviously we're going to be monitoring the situation and these broader types of initiatives closely as it progresses.
Okay. How can technology and the architecture of the internet be used to make the rules on digital trade more accessible, understandable, and functional? You want to start, Nick?
Me, Nick, or Nick Russell?
Okay. Whomever would like to start.
Nick, go ahead.
I mean, there's an interesting question here about whether the rules of digital trade can ever be accessible, because it's not bedtime reading, and it is a specialized kind of legal reading essentially of a text. You have to understand how to read the kind of cross references, the general exceptions, the non-conforming measures, and kind of all that within it. And it is it's a question that I've spent a while trying to figure out. Is there must be a way we can do this? We can do this better. We don't write trade agreements for ourselves. We write them for the people who use them, for the businesses, consumers, and such like. If anyone wants to drop any great ideas about how we can do that, then great, because I've always felt there's been a difference. Whenever you do a free trade agreement, you always release as well the kind of high level lines which paint the kind of broad picture of it. Then you have the legal text, which has the real kind of nitty gritty implementation of it. What the kind of potential is for actually some kind of product that helps to real world it, the rest of it, and also and this is kind of me, hypothesizing out loud, really, that one of the things about digital is that digital is inherently international, firstly, and it's in how it's set up. You don't really build kind of national only digital like digital companies or such like. It's also quickly changing and such like. And I do think sometimes that you can get a bit of a conflict between the architecture of an FTA and the nature of the digital economy, both in terms of how rapidly it evolves and in how naturally it reaches kind of more widely. So I don't have any solutions, but I do think it's a really interesting area that we could and should maybe understand more about.
Susan, if I may, and I'm aware of the time, but I just wanted to mention that we've been working with a bunch of lovely and very smart people that work at the X-Algorithms Foundation, and they have developed a methodology in order to translate, or so to say, translate trade agreements from natural language into a computer understandable and processable kind of code. We are currently working on a pilot project in order that will serve the purpose to allow people to understand what, in a more direct way, what trade agreements are about. And this will also allow people to find out if there are opportunities in order to trade, to export, to import, and whatever. But it will also allow people to, or international trade agents, to automatize certain parts of the process of import-export, but we're also expanding this to services and to intellectual property. So if you want to find about this methodology, I would encourage you to go into xalgorithms.org, and it's all open source. Everything is available. and you can even download the software and use it for by yourself.
Fabulous. Thank you. Darren, do you want to add anything?
Just a quick word that I totally agree that we need to continue to try to up our game, do a better job in terms of explaining not just the benefits of these agreements once they're complete, but actually how they actually function, how they work, and whether there's some interpretation that needs to be provided to users. I agree with Nicholas that both Nicholases, in fact, that we should be writing these agreements with the users in mind, and sometimes we don't. We're obviously working off of past language, past precedent in terms of how we approach these things, and especially when you're dealing with a chapter in an FTA, you have to understand how it works as part of its holistic package, and that's not easy either. So it means more training, more opportunities for you, Susan, to get out there and work with stakeholders and explain to industry and civil society and other academics how these things work. It just takes effort, and we have to build into our post-implementation work plan basically that it kind of education function has to be part of our outreach.
Thank you so much for that. I'm ready. Can you guys stay for one more question, or do you need to go?
I'm good.
Okay, one more question is about development. Is digital development industrialization policies protectionist? So maybe an example would be infant industry protections for data. Or it depends on the policies.
I think that's exactly it. It depends on the exact policies themselves. We all have, as part of our domestic industrial policy framework, efforts to try to support, young companies, young industries, especially as those who are in this case are adopting to digital transformation. But is being done in such a way that it is inherently discriminatory against foreign suppliers in this case. And you don't have to have it that way. I think you can still have an open commercial environment and still support and help your companies grow and become internationally competitive.
Anyone else?
Yeah, us being a developing economy, we also found out that we actually have a lot to offer to the world. This might not be this is something that we didn't knew, but for instance, we do have a very striving video games developing industry that is exporting services and digital products to the world. This is something that we didn't knew. So I think going back to the question, it all depends on the niche where you want to develop, and everybody has this traditional notion of competitive advantages. I think you have to be ready to see where those advantages are and take advantage of them, and that's sort of what we've been doing, and having this open global platform as that the internet is really key to us, because we can reach everybody with lower barriers to entry into those markets.
Nick, did you want to add anything? Nick Russell?
I think Darren and Nicholas have covered it pretty well. I mean, the question I would have is why you'd want to be protectionist. There's so many opportunities, given the nature of how digital is, for us to really kind of for markets to grow pretty quickly, whether you're coming from a kind of more or less developed country. So I find it difficult to make a precise definitions of this is protectionist, this isn't protectionist. It's a kind of it when you see it type of thing. But a kind of encouragement to not necessarily think of that as the default way of helping economic growth, particularly in the digital environment.
That's a wonderful comment to end this webinar. Can I thank you, Nicholas, Nick, and Darren for participating with us. It's not often that one can get trade negotiators to speak, and I really appreciate it when trade negotiators do, because I think it helps so much. So thank you so much for participating today, and I hope we can call on you again. And to our audience, thank you so much for coming. And if you have further questions or ideas for webinars, we really want to hear them. And then finally, thank you to our co-organizers. Everybody have a great day. Thank you. Bye.